use the assets for the future trades. SEBI has come up with a mandatory requirement that the stockbrokers have to return these assets at least once in a quarter to these clients. Then it can be got back. So this is an investor empowering circular which SEBI had issued on the stockbrokers to prevent misuse of the client's assets by the stockbrokers. But when it comes to fraud, see, this circular issued towards strengthening the investor interest, but this circular has paved way for innovation on the part of the stockbrokers in circumventing the requirements. So SEBI, during its relentless inspection of the stockbrokers regarding this compliance, has brought out how these provisions of the circulars are being misused by the stockbrokers, and exemplary punishments have been brought on the stockbrokers wherever there is a case of misuse of the client's assets. Then comes this agency problem. Agency problem or the principal agent problem, it can be called as. See, agents, which include company management, brokers, employees of firms, etc., they act in a manner that is prejudicial to the interests of the principals, that is shareholders, clients, etc., by taking decisions that maximize their selfish benefits. So window dressing of financial statements, taking risky investments to earn more commissions, etc., are some manifestations of this agency problem. So in this case, I would like to say there was a beautiful description of fraud, the nature of fraud and who commits fraud, that was given by the dignitary who has given the keynote address. So, but what is the essence of that? See, everything percolates to this is fraud can be committed. It is the thinking from an individual. It is a thinking from an individual that is to be realized. See, frauds are committed, it is by intelligent thinking, circumventing the rules and regulations. This intelligent thinking, what regulations can be made to regulate the thinking of an individual? That is something which has to be appreciated. So apart from this, we have made inroads into this insider trading, where in 2013 we have made massive amendments to our insider trading rules and regulations, where this concept of insider trading has been, the definition of who is an insider has been extended to such an extent it brings all the key persons associated with the inside information under book. Not only that, not only by extending the definition, even their market activities, who is possessing such inside information, it is also being regulated. They cannot trade in the shares and securities of that company for next 6 months. Whenever some sensitive information is available or sensitive decisions are taken, these kind of restrictions have also been made by SEBI to protect the interest of the investors. And the basic principle in this insider trading is now, from that earlier days of, it is for SEBI to prove who is an insider, it is for an insider to prove his innocence than SEBI to prove the guilty on the part of the investor. See, this is a paradigm shift that has taken place in this regulation. Then you all know about this, you all heard about the CAS and Ponzi schemes. See, CAS regulations, you say as of today, as on date, there is only a single entity which has registered with SEBI under CAS regulations, even though the CAS regulations have come into place in the year 1999. But so many fraudulent activities take place under the name of illegal CAS. What does this signify? Is there any problem in the regulations? Or is the regulation is so tough that people cannot comply with that? Or is it choking these investors from the companies from mobilizing money? No. See, this CAS concept was in existence, continued to be in existence even in the early stages of liberalized era. When this mobilizing money through public issues have been liberalized by SEBI and norms have been eased, still people, instead of preferring to mobilize money through these public issues, people preferred these equity schemes, timeshares. This only indicates the tendency for some of the people to remain outside the regulatory purview. How could that activities can be curbed? Through a preventive regulation. So these things can happen only as a reactive action by SEBI. So I will, before concluding, I will just give you some few points how some of the cases where SEBI has tackled these challenges of fraudulent activities in the capital market. SEBI has prescribed a code of conduct for each category of the market intermediary, by which the intermediary is expected to act in a manner that does not compromise the client's interests, and exemplary punishments are meted out if there is a breach of this code of conduct by the intermediaries. Then there cannot be a reckless or irresponsible investment advice not relevant to the risk profile of the client. Investment advisors and research analysts, we have granted registration. We have brought the activities of these entities under SEBI regulatory purview. And we have prescribed a code of conduct. Not only that, their advice has to be associated, linked to the risk profile of the client to whom they advise. They cannot make reckless advices. And stringent punishments have been imposed on the perpetrators of fraud in the capital market while acting as an intermediary or by acting as a company mobilizing money from public in an illegal manner. You see, so that's what somebody said, 3S, Sagara, Sarada and Satyam. People were saying, you know the condition of Sagara, and 24,000 crores have been mobilized. People, what did they say? They said OFCD, optional fully convertible debentures. And from whom they mobilized? They called it as private placement. How many people were involved in the private placement? More than 1 million. The regulatory requirement prevailing at that time for private placement to be less than 49. More than 1 million people, and it's called as OFCD, such a technical jargon. And who are the people from whom it has been taken? From the people in the lowest level of the society. What do they know about OFCD, or its expansion, or its purpose? So this is the kind of frauds that have been perpetrated. No, and they maintained the stand that it was a private placement and SEBI has no role to play. And this is the proactive step SEBI has taken in this case. When they came to SEBI in a different matter, SEBI started probing into the collection of mobilization of this money. When SEBI wanted information, maximum non-cooperation was given by the company to SEBI. SEBI had to resort to the exemplary punishment of passing 11B orders, debarring them from the market. They went to Supreme Court. Supreme Court had upheld the actions of SEBI. More than 24,000 crores mobilized, out of which 11,000 crores have been realized by SEBI as on date. And in this, about 55 crores have been disposed, given back to the investors. More than 12,000 applications have been received from the investors and the money has been disbursed to these investors. A special cell has been formed by SEBI to exclusively look into this Sagara's claims. Similarly, PACL. PACL is something which we need to mention. PACL is another high profile case. SEBI had taken action against PACL way back somewhere in 2002. And when they did not register with under the CAS regulations, SEBI had taken action. SEBI said they cannot mobilize money. PACL went to court. They went to Honorable High Court of Rajasthan. In India, with due respects to the judiciary, in India, judiciary can be bought sometimes. So within the four walls of this, I would like to say that with due respects, this is a company formed, incorporated in Gurgaon. They contested our order in High Court of Rajasthan. SEBI pleaded with the court that they should be, their order should include that they should not mobilize money further. But court had left it without making any order in this regard. The company went ahead in mobilizing money, but SEBI did not leave it at that. SEBI had filed an appeal in Supreme Court also. And again, the judicial process, it took more than 10 years, 12 years for the case to come up. And now you can see what is the condition for PACL. SEBI is making relentless efforts even in recovering the assets created by these companies through this mobilization of money through unauthorized means. SEBI has even written to Australian authorities where the properties have been identified in that country to bring back, to realize the money. So these are some, this is only to just, I thought it is really the duty of SEBI to give a different perspective about, as a regulator, what SEBI is doing in the capital market. So like, see, it is capital market is like a water body. These frauds will be there in the, maybe it will be in the peripheral, in the surfaces, in the peripheral areas. So this should not deter the investors from entering the capital market. These mosses will be cleared. Regulator is there to do that. Regulator is doing that. Indian capital market is in the safest hands now. It has been acknowledged by the government of successive governments, irrespective of their political affiliation. So you can be more assured of that you are in the, your investments in the capital market is in safe hands. So you see the different perspective from outside these institutional walls. So with that, I would like to conclude this. Thank you all. Thanks for the opportunity. Thank you.
Thank you, sir, for a wonderful exposition of both the agency problem as well as the regulatory problems. And then you have given good examples also. Now we would let us listen to Ms. Sunita Anand also. Madam, take the time into your...
Thank you. Respected dignitaries on the dais, respected academicians of the dais,